Good evening. You're watching The Digital Age, and my name is James Goodale. President Bush has nominated Michael Mukasey to be the Attorney General of the United States. The hearings are coming up shortly. His view as to terrorist trials will be a key issue in those hearings, no doubt. He has written that he does not think that federal courts, nominally constituted, is the right place to trial terrorists. But yet he tried one of the great terrorist trials of all time, the Blind Sheikh case, and the Blind Sheikh was convicted. How can it be that Michael Mukasey is against trying terrorists in federal courts, but yet sat over one of the more successful governmental prosecution of terrorists? Is he right about terrorist trials? Here to discuss that question with us tonight is Carl Mayer of the Carl Mayer Law Group, Princeton, New Jersey, a public interest lawyer, and Andrew McCarthy, a former prosecutor.
Good to see you.
Thank you for coming by.
Thank you.
Andy, let's start with you, because you're going to play a key part in these hearings because, number one, you were, along with Pat Fitzgerald, the chief prosecutor of the Blind Sheikh. Right. You actually tried this case in front of Judge Mukasey. Right. The second reason that you're important is that Mukasey said he didn't think the courts, federal courts, were the right place to try terrorists, and said so in a Wall Street Journal article. And he said, there's this guy, Andy McCarthy, who's really thought this through, and we ought to maybe follow his solution. I don't want to get to the solution until we're into the program a little bit, but I do want to ask you about this case. What was it about this case that made, oh, and you agree with Mukasey too, apparently. Yeah, what is it? You got the prosecutor, you've got the judge. What was about this case that led you both to conclude that you should have lost it, basically?
Well, no, I don't. I think Judge Mukasey's been a little less categorical than you're describing.
Oh,
I don't think he's not saying that we necessarily should adopt an idea I've proposed, which is having a national security court. But what he has said is that it's not an easy mesh to provide the kind of due process that we have to provide to bring criminal trials up to the standards we expect, and to handle the national security challenges of terrorism. Right. And primarily, those have to do with the intelligence that you have to give out, that you have to disclose in the course of a criminal trial. And the challenge that we confronted was, during the course of the trial, which takes place within the greater framework of a global jihad against the United States, we're actually turning over to the people trying to kill us the information about what we know about them, our methods of collecting that intelligence, our sources for that intelligence. The trial works in terms of according due process to terrorists. You can show that our trials are satisfactory from that perspective. But as a national security strategy, it's not really an acceptable alternative, because if you look at the terrorism trials of the 1990s, we had about 9 trials, 6 majors, 3 somewhat less substantial. From 1993 until 2001, from the bombing of the World Trade Center until the World Trade Center was destroyed. In the course of that time, during a time where everybody agrees that the enemy we're facing was growing bigger, we managed to neutralize less than 3 dozen terrorists. And for the most part, other than a handful of people like the Blind Sheikh and Ramzi Youssef and 1 or 2 of the 1998 embassy bombers, most of them were the bottom of the barrel of terrorism. We did not, for example, bin Laden has been under indictment in the United States since June 1998. That's before the embassy bombing, before the Millennium Plot, before the bombing of the USS Cole, and before 9/11. So obviously, adding counts to the indictment isn't deterring him much.
Well, let me just put another statistic in there.
Sure.
Because you were in the Southern District here in New York, which is a great place for U.S. attorneys, and you had Mary Jo White as your boss. She's now a partner in a law firm. She she charged 20 terrorists. She convicted 20 terrorists. Now I'll let you respond.
I think it's more like 40, actually.
Is it more? Yeah. More than that? But anyway, there were no losses. I'll let you come back and talk to me about that. But I want to get Carl's reaction to what Andy has said, and maybe with respect to what I've just said. I mean, I look at this, and the record looks I mean, 30 looks pretty good. 40 looks pretty good. I mean, how many people has the Bush administration convicted, by the way? 1 or 2. So what do you think?
Right. I think it's a wrong-footed way for Mukasey to start in this nomination proceeding, and I think it's an ill-considered idea, because essentially Mukasey and Andrew are arguing against their own success. It's the promise of our nation that we will show to the world that our constitutional procedures and safeguards, as evinced through federal court procedures, work. And they did work. These terrorists were convicted. They were brought to justice. The only citation to any national security issue that I saw in Mr. Mukasey's opinion in the Wall Street Journal was that somehow the word got back to bin Laden that he might be implicated in that plot. Well, I think bin Laden knew for a very long time that he was a suspect and very much on the radar of American intelligence and law enforcement services. So I don't think this measure is helpful at all. In fact, I think it's continuing an effort by hawks in the national security area to circumvent the judiciary and conventional judicial processes and try to further establish a unitary, all-powerful executive. We're trying, in this proposal, what Andrew and Mr. Mukasey are saying is, listen, the Constitution is fine for regular criminals, but for people that, as Mukasey calls, have some cosmic mission with cataclysmic consequences, well, we need a separate court for them. And I just think that's not the right approach. I also think that his opinion piece was written in order, I believe, to signal to the security hawks in the Republican Party that he is with them on these issues. I think that's wrong-footed. He should be assuring the American people in these confirmation hearings that nothing that went on under Gonzalez will go on under his administration, that he will stop supporting torture, that he will make sure the Justice Department no longer writes memos that support torture, that he will make sure that the Justice Department no longer sanctions U.S. attorneys for engaging in too much political corruption prosecution. Those are the types of things that the American people are concerned about. I don't think this carving off some sort of special mechanism that further diminishes the power of the judiciary to oversee what the executive does. In fact, he even calls for a lack of Supreme Court oversight of these special courts. He indicates that maybe it's time to have trials for these terrorists that isn't supervised by the Supreme Court. There's no appellate procedure for the Supreme Court. So where are we going with this? Are we going to not present evidence to defendants? Are we going to allow evidence that is admitted through torture? How would these secret courts work? Or these I think it very much goes against not just the Constitution, but what people think of as the importance of the American judicial process.
Well, he's put a lot on the plate there, right, including how Mike Mukasey will administer the department. And also he's put on the table what you have proposed, and we haven't really talked about what you proposed. But before you get to that, I wanted to come back to his first point, if I can, and it was your last point, which is that probably the principal objection is that these trials in federal courts disclose too much to the enemy.
Correct.
Okay.
Right.
Now let's pick up the example that Carl talked about and Mr. Mukasey talked about.
Right, which needs to be clarified, because the way Carl described it is not quite what happened.
Okay, so just to refresh everyone's recollection,
right,
what the point was that the trial of the blind sheikh caused bin Laden to know that he had been made part of an indictment.
No, what happened was, complying with Second Circuit law, we had to provide to the defense what's called a list of unindicted co-conspirators, which is just to let the other side know people who might come up, whose names might come up in the evidence, so that they can prepare for trial, because the Justice Department doesn't let you put that kind of stuff in an indictment when people haven't been charged. We provided a list of 200 people and entities that were on the government's radar screen, which is a very valuable piece of intelligence to have if you are the head of an international terror network, because it tells you in a way that nothing else does who is on the government's radar screen. Some of the people might be completely innocent, but some of them might be hot numbers that you just haven't collected evidence against. it also alerts you to the fact that if the government knows about these people and their participation, that you're compromised in some way. Maybe there's an informant, maybe there are wiretaps, maybe there are other avenues that the government has in order to collect information. And what this all goes to, which is a lot more than bin Laden knowing he was under investigation, what this all goes to is the fact that there are two responsibilities that the executive branch has. One of them, of course, is to enforce the laws. The other is to protect national security. And the Justice Department's scorecard, the percentage of victories that you have of the people that you indict, even if you bat 1,000, that doesn't make it an acceptable national security strategy.
May not.
Right. Well, no, does not.
We don't know.
Well, no, I think we do know, actually. If you prosecute less than 3 dozen people while the other side is getting bigger and bigger, and they attack you more audaciously at least once a year over a course of 8 years, I think you can probably sensibly say that what we're doing here may work for due process, but it doesn't work for national security.
Can I just add?
I want to stress, Judge Mukasey has not adopted all of the, the various menu that Carl described. He's said that it's stuff that we should look into. My proposal, which he pointed to but did not adopt it his own, also undermines one of the points that Carl made, which is judicial supervision. Contrary to what the administration has done in military commissions, what I've proposed is that we should take some of the procedural aspects of the military commissions, but the cases should be supervised by an Article III judge.
What does that mean?
Means, I'm sorry, a regular federal court judge, just like Judge Mukasey was, and just like the other judges who sat on terrorism cases. And it would go up the ladder through the appellate system, just like regular criminal cases do. We're talking about how do we protect intelligence, and how do we make sure that we're not edifying the enemy at wartime and giving them the tools that they need to kill Americans.
Okay, well, let me just go back, because that's where I started on the how do we protect intelligence point. Mary Jo White, who was 30 for 30 or 40 for 40, but anyway, 100%, which is pretty good for a lawyer, may not have gotten the other 1,000 or whatever Annie thinks is out there, has written an article in which she tries to deal with the same problem that Annie does. She said, with respect to classified information that comes up at a trial, and I think we would agree that a list of unindicted co-conspirators is classified information. She has said, effectively, I don't want to speak too much for her, she can speak for herself better than I, that it's manageable. You can manage the introduction of classified information into a courtroom, because you can keep the public out. You can swear the lawyers to secrecy. It's done more often than not in these kind of cases. You can seal the indictment. The indictment against bin Laden in 1998 was sealed. This earlier indictment was not, apparently. So isn't that the answer to the principal problem with all these cases that gentlemen such as Andy McCarthy bring up?
Well, I think it's one answer, particularly since we don't really have any evidence that somehow turning over these names has in fact compromised United States security. In fact, Judge Mukasey, in his opinion piece, points to the British system, which has a system of trials that he would like, a specialized court, and being able to hold people with detention without charges. He points to their system as superior to ours, and yet Al-Qaeda managed an attack since 9/11 on British soil, but not on United States soil. It seems to me that all these, all of these procedural safeguards are in place, and yet we still have managed to not only convict terrorists in United States courts, but there hasn't been an attack on U.S. soil. So, in conventional parlance, if it ain't broke, don't fix it. It's working. I think it's working, and the point is exactly right. The judge could review these issues or review a list of unindicted co-conspirators in chambers, meaning without public.
He closed the door.
Closed the door, right? Without public inspection. So, what I'm really concerned about with Judge Mukasey is that he's focusing too much on, again, enhancing executive power and prosecutorial power. And even though Andrew's proposal, I think, is an intelligent one in that it has Article 3 judges review it, there's a lot of unanswered questions. Can you use testimony obtained by torture? Does the person have the right to confront their accuser? All the constitutional safeguards that we guarantee as part of our liberties, would those apply in these courts? And would there be ultimate Supreme Court review? Now, maybe if Andrew is saying, yes, we should have Supreme Court review of this, that's different than what Judge Mukasey was suggesting in his article. And one should also note that at least Judge Mukasey was saying that his proposal for separate courts, he would submit to Congress rather than imposed by executive fiat, which the administration has done in the past.
Okay, well, let's pick up on you. Number one, how about treating classified information secretly? Sub-question, did you do it in your trial? As a matter of fact, then how about the main thrust of his point, that you're throwing all the constitutional rights that we have won all these years with your proposal?
Well, let's work backwards for a second.
Okay.
I quite agree with Carl about the constitutional guarantees. That's why one of the things that we're hoping for is, I think he's absolutely right, this is something that has to be done by Congress. And it's got to be something that people look at and decide what are the baseline guarantees of due process that we owe alien enemy combatants in wartime. I don't think Congress should kick that over to the courts. I don't think the executive branch should decide that on its own. I think the legitimacy of the project demands that it's a democratic endeavor that we bring as many people aboard as we can. As far as Mary Jo's point about whether it's manageable or not, you know, the list of unindicted co-conspirators in our trial was not classified. It was one of the many things that come up in a trial that the government has to turn over. Basically, it's something you can. Sure, you could classify.
You could classify.
But let me ask you this, or let me ask you both
Is that
this.
the public's problem if the government screws up?
Well, no. Well, it becomes the government's problem if, whether the government screws up or not, people who get the discovery disseminate it to people that they're not supposed to disseminate it to, which is what happens, first of all. And secondly, in this country, the Supreme Court has said that you have a constitutional right to represent yourself. That if you say, I want to be my own lawyer, there's nothing we can do about that. Now, are you proposing that if we arrest Zawahiri, the number 2 guy in Al-Qaeda, and we bring him here and he decides, I want to be my own lawyer, that we have to give him all of the classified information
Are
that
you
we could give his
proposing
counsel?
that? Are you proposing that,
Because
Carl
that's what he needs to get due process. That's the information that he's going to be tried on. Are we saying that we need to give our most precious classified information to the number 2 guy in Al-Qaeda?
Well, I don't know how, I don't know whether it's our most precious classified information, but a list of unindicted co-conspirators.
I'm talking about all the discovery in the trial,
right,
including the classified discovery, including the methods and sources. Sure.
Please do.
In the first bombing of the World Trade Center,
Right.
Which was planned by the very same person that planned the second bombing of the
I don't know if we know that, but okay.
well, his nephew. His nephew did it for sure, okay?
Right,
And let's just talk about his nephew. And K.S. Mohammed is the
Right.
person who definitely planted 9/11 and everything else according to him, and perhaps the first bombing. And it's quite clear Ramzi Youssef
Fair enough, yes.
did plan and cause the first World Trade Center disaster. He represented himself, okay?
Right.
And I just want to ask you, as a matter of, did that representation damage national security?
That one did not, and the reason was he was narrowly tried in the case where he represented himself on the World Trade Center bombing, which by then had happened 3 or 4 years before and was a horrendous crime, but a single transaction crime where the amount of discovery was finite, and in order to prosecute the case, you didn't have to bring in the whole Al-Qaeda conspiracy. If he had represented himself, say, and he wasn't implicated in this, but if a defendant had represented himself, say, in the 1998 embassy bombing, where we actually did charge the Al-Qaeda conspiracy, the problem with terrorism trials is they have to be charged broadly because the government wants to take advantage of all of the favorable conspiracy law. But the more broadly you charge something, the more you're going to attach discovery obligations. And the trajectory of that is to force yourself to have to turn over discovery about the people that you're fighting at the time that you're trying it.
Okay, let's break quickly. You want to respond to that? Go ahead.
Well, just you know the old phrase, whoever represents himself has a fool for a client. You don't know how capable these defendants are going to be in requesting what you call national security information. Plus, there's still no evidence that anything turned over at trial has compromised national security.
They don't care about whether they get convicted or not. They know they're going to be convicted. This is a sacrifice, just like killing yourself by driving a plane into the World Trade Center. This is a sacrifice that you make for the greater good of the jihadist organization. Zawahiri, if he gets indicted, will be convicted. The trial will be an exercise, but it will be an exercise during which he can do a lot of damage to our national security.
We don't know what damage he'll do, and in the meantime, we're saying to the world that we, as a democratic nation, have a standard. And that's what makes us important in the world. And unless we do these trials and attach all the protections, I think we're adding to the recruits of jihad and to Al-Qaeda, because it is what makes us a democracy, and that is what separates us from dictatorships. So we should, you know, as Brandeis said, the people who won freedom for this country, they understood that fear breeds repression, and that courage is the key to liberty. So we have to have the courage. We have to have the courage to adhere to our constitutional procedures, even if there are moments where the opponent might gain some advantage in national security terms. I have yet to see an instance where that occurs, but that is the price of a constitutional system, and I think the price that America is paying in the world for all these extra constitutional measures that the Bush administration is taking in terms of sanctioning torture through Justice Department memos, through the being rebuked by the Supreme Court for the special military commissions, all of these efforts to circumvent the judicial branch in the Constitution are very much not just damaging our credibility, but they become enormously unpopular. And going into these hearings, I think that's the central issue, is will Judge Mukasey right the wrongs of Alberto Gonzales? And this issue, although important, I think he's throwing up as a distraction, if you will, from real serious concerns about adhering to the Constitution, to the point where the American Bar Association and hundreds of thousands of lawyers nationwide have written to the president citing former counsel for the CIA, the NSA, saying these unconstitutional mechanisms that you're creating, these extra constitutional mechanisms you're creating to allow torture, special courts, etc., are damaging our country.
Can I pick up on the question of what Mukasey should do, will do, so forth at the upcoming hearing? He's written this article in which he's raised a question as to whether the present system, which is not in federal courts, works, by saying, I think we ought to rethink this. And we've got this guy McCarthy. He's rethought it. I'm not saying I'm going to adopt McCarthy's proposals, but you know, he's rethought it. How does he go up and testify when the issue of these courts is still a live one? I don't want to get into all the technicalities, but it's before the Supreme Court, and there's a case here, there's a case here. No one knows whether the present system is any good at all. Shouldn't he go up and back the present system rather than say, "Hey, McCarthy's got a better idea than the present system"?
Well, no, and I think this goes to a point that Carl made. The Supreme Court didn't exactly rebuke the idea of courts other than the civilian courts that we use. What they did was they rebuked the notion that the president could unilaterally direct them, but they affirmed the notion of having military commissions, and in fact asked Congress to come in and do some reparations work. Congress then turned around and blessed the military commissions. What we're talking about is, given that the Supreme Court has recognized that you can detain people indefinitely in wartime, and that you can try them by military commissions as long as Congress signs off on it, that's our baseline. Shouldn't we explore whether we can do better? Knowing that you have that and that you can do things that way, and there's that paradigm, and then you have the full flower of the civilian criminal justice system. Is there something in between that marries up the best parts in each system without compromising our national security, but still gives people more procedural protection than what the Supreme Court says they're entitled to?
But let me just put the same thing to you. Andy's is being reasonable because, of course, he always is. But he's got a proposal that's in the middle. But let me pick up again. Mr. Mukasey's sitting there before the Senate hearing, before the Senate committee, and how does he say all of a sudden I've got something that's that we ought to think about that's in the middle, when the Congress has already thought about it and they've come out with the present situation? I don't think Congress is sitting there that they ought to take back what they've come up with. How do we do that? How does Mukasey dance around that? And if you were advising him, what would you tell him to do? And I don't mean McCarthy advisor, I mean you advise him.
Well, he's already got Andy, and he wholesale endorsed Andy's work. And,
not quite wholesale.
No, not quite, but
no, I mean, it's a serious question.
So,
but you know, you raise all these problems that you've said what he should do. Yeah. So I'm asking you what he should say at the hearing, and particularly with respect to what Andy has got in mind.
Well, if he's dead set on approaching the Congress with this idea, then he has to make clear it's that the Congress has the authority, not the executive, to ram through this idea. But I think he's basically asking the Congress for a different type of a different type of system for what he calls cataclysmic events that are or cosmic events, right. And he has to define what he means by how you select who will go before these courts and who will not go before these courts. He's got to define whether the Supreme Court gets to review these cases or not, and he certainly has got to say we can't have secret evidence, torture evidence, and the inability to confront your accuser. If he doesn't make it clear what he believes on those points, I don't think Congress is going to look at this proposal as credible. And I'm sure he and Andy have thought through what is credible and what is not.
Have you talked to him about his hearing?
I've congratulated him on his nomination, and I would point out, but you know, the article that he wrote was not written as a nominee; it was written as somebody who.
What everyone says it was an advertisement for his nomination. We've come to an end. Andy McCarthy.
Right.
Is Mukasey right or wrong?
He's right.
He's always right. Are you right or wrong?
I'm here, Arn.
Carl Mayer, is Judge Mukasey right or wrong, and is Andy McCarthy right or wrong?
Andy's always right. Mukasey is wrong, and Mukasey has to stand up to reverse what Gonzalez has done to the Justice Department. He has to.
Thank you guys for coming by, and thank you all for coming by too. Come by next week and learn more about the digital age. For the digital age, I am James Goodale. Good night.